Folks, we're back. This is Steve Sanchez, Jim Jonas with another episode of Veterans in Politics. Today, our guest is going to be Paul Gaudet. He's a Clark County District Court Judge, Family Division, Department N. But before we get to Mr. Gaudet, Jim, you have any rants?
Yeah, just one. And I'm going to make this real quick because I'm very excited to have Judge on because family court is something like we...
Something? I've never heard you speak like that before. You've been hanging around me too much.
We've been very focused on, so this should be a great interview. But I want to say it was like 4, maybe 5 programs ago. You specifically speak about how you thought that the world is getting a little more dangerous. And that we were, and as far as the military goes, we're having troubles recruiting because of some of the budget cutbacks with
stupid decisions.
Yeah, stupid decisions, clothing allowance that being thrown out, and then, storage for people to get, when they
deployed and they got to pay for their storage.
Right, yeah. So it was interesting because yesterday I was surfing the internet and come to find out there's this huge problem that's occurring in the Red Sea. Okay. So there's a terrorist group that is basically in northern Yemen. Okay. And so they've been attacking not military ships, but just regular ships carrying cargo. And it's causing a lot of issues because what's happening is it's instead of being able to go through the Red Sea, they have to go around the Horn of Africa. Mm-hmm. So this is something that came up on the Pentagon's radar a couple months ago. Well, actually, on Tuesday at 11:30, they actually fired on one of our destroyers. And thankfully, we shot it down. But this keeps escalating. And like a lot of people are not aware of this issue. Now, like individuals like us that pay attention to these things, we are aware of it. But I think everybody needs to be aware of and for me, I'm trying to make this as apolitical as possible. But I find it ironic, or it's something that people need to be aware of, that when the United States is perceived as weak, which we are right now militarily, okay, then stuff like this seems to increase.
It's like a bully in school.
Yeah. So it's like, and I'm bringing this up in particular because we got the caucuses going on right now. It's primary season. Voters, you really have to educate yourself and understand these things. And yeah, Yemen may not seem like much to you, okay? But it is something that's important. And if other countries, specifically countries that are enemies of the United States, if we're perceived as being weak, they're going to take advantage of that. So you need to start making sure you listen to podcasts like this and just educate yourself. I'm not saying vote Republican, vote Democrat. I'm just saying educate yourself, be abreast of the issues and what's going on, because Yemen may not seem like a big deal to you, but actually it is. So just educate yourselves, keep your eyes open, and pay attention to world facts and what's going on in the world. I know everybody has a lot going on. You got mortgage payments to make, you got bills to pay, but you know what? At some point, the enemy that's over there will come here at some point. So just keep abreast of that.
Funny you say that because I voted today in early voting, the primary.
Yeah.
None of the above. And the voting booths were empty.
Yep.
There was hardly anybody in there. I mean, because we have the caucus as well, so everybody's waiting for the caucus, right?
Yeah.
But in the primary, I make sure that I voted, and I make sure it was none of the above. With that said, we have our Valentine's Day ball this Saturday, February 3rd, at the South Point Hotel. The room is by the bowling alley. So 5 to 6 is a cocktail hour, 6 to 8 is dinner and dancing. After 8 is dancing. And we're going to have auctions and we're going to have a great time. We're going to have a DJ. We're going to have great speakers. We have Judge Timothy Williams that's going to be speaking. We have Congresswoman Rattlewagon that's also going to be speaking. So it's going to be an exciting time. If you haven't received your tickets yet, go to Eventbrite and get your tickets and get them quickly because Saturday is right around the corner and we got over 100 people showing up in attendance. So I'm closing everything off tomorrow. So, but it's going to be fun. Come on down. Have anything else?
Yeah.
Okay. Mr. Gaudet.
Yes, sir.
Or, sorry.
Judge
Gaudet.
Yes, sir.
How you doing, sir?
I'm doing great. Thank you.
I'm so used to saying Mr. and Mistress because all these candidates that are coming on the show that are not the incumbent, and you are the incumbent.
Anything but late for dinner. Don't call me late for dinner.
Don't call you late for dinner. You got the gavel right there.
Yes, sir.
Judge Gaudet, tell us about you.
Personal background?
Yeah.
58 years old. I've been in Clark County since 1992. I completed my undergrad in 1987.
Where'd you hail from?
I like to say New Orleans, a little town about 35 miles outside of New Orleans. I say New Orleans, people can assimilate to that. A very small town. I like to say about 10,000 people. That's probably higher. We probably had 6,500 people. Geographically, if you're familiar with the South, there's about 70 miles between Baton Rouge and New Orleans on the I-10. Baton Rouge being on the west side, New Orleans being on the east side. I grew up in a town smack dab in the middle. It was about 34, 35 miles either way. Really neat place to grow up because we had the small town environment. But if you wanted the city, you could go east or west and basically be in both. Not 30 minutes, but 35, 40 minutes. So it was a really, really cool place. But I completed my undergrad there in 1987. 1987. Always having the intention to go to law school, but my mom and dad, I came from a basic, we had a nice lifestyle. I wouldn't want anybody to feel sorry for me, but my mom and dad didn't have the money to put me through law school. So, which was one of the reasons why I majored in accounting. I figured I could, the bean counters always have a job. And I figured it would give me the opportunity to get some work to save some money to go to school. And that's what I did. I went to school for 2 years. And then after that 2-year period of time, I started law school. I finished law school in 1992. By that time, I was married. I didn't participate in my commencement program because the wife and I, she was a startup stockbroker. I was a startup attorney. We had to get out here and make some. We had by that time we had chosen to live in Clark County, Nevada. So I got to Nevada. I finished my test early that year. It was just the way my tests worked out my last semester. We were in Nevada prior to the end of April. I'm going to say probably the second or third week of April of 92 is when I actually moved here. I've now been in Clark County, Nevada for almost 32 years. I was licensed to practice law in October of 1992. I'm now in my.
How long did it take you to pass the bar?
Oh, first time, Steve. Oh. Come on. I'll tell you. I'll tell you a funny story about that. You reap what you sow. You put a lot of time in. When I took the bar exam, it was, I don't remember if it was 3 or 4 days, but we took it over at Cashman Field. And every day following the commencement of the test for that day, you'd walk outside. And I don't know how many people, I mean, there were a bunch of people taking the bar exam, but boy, people would meet in little groups and they would discuss. And I was of the mindset, why meet in those groups and discuss it? We've turned our test in. And the last day, and I'll never forget this, that there was a guy, ironically, that had moved here from New Orleans right at the same time I did. We became really good friends. We're actually born on the same day, the same year. And he had called me over that last day, and he was talking to a group of people, and he said, how do you feel about the exam? And I actually said, I feel like I put too much time into the exam. You want to be as prepared as you possibly can be, yes. But let's face it, it's pass-fail. And I don't say this to sound pompous in the slightest. When I turned in that last exam, I felt very, very confident that I had passed the exam. But by the same token, you reap what you sow. I put a lot of time into the preparation for the exam, so I felt very, very confident. And sure enough, I don't know when. This is another funny story too. We didn't have internet access to be able to check. You actually had to call in to get your scores, and it was on a Friday. And I called in, and the young lady with the I say young lady, the lady with the State Bar Association, she asked for my name, and I think she asked for my Social Security, our last four of my Social Security number. And she said, well, Paul, she said, I have some bad news for you. That was the only point that I actually stopped. I said, bad news. She goes, yeah. She goes, I got to tell you, you passed the exam, you're going to be an attorney. So that was my experience. And I think that was, we probably sat for the exam in July. We had our results. I know I was sworn in October of 1992. So I'm in my 32nd year of practice.
Where you went?
Yeah, got me there, Steve. I want to say all the members of the Supreme Court were there, and they probably swore us all in at the same time. Back in 1992, Las Vegas, which is one of the reasons I moved here, I want to say we were 550,000 people. I wouldn't think the state, I had looked at a lot of demographic studies and stuff when I moved here. I wouldn't think the state was much over 1 million, 1.2 million, maybe 1.3 million at that time.
So it was about 1.3.
Yeah. So what was really cool?
And what year?
1992. I don't think.
No, it was lower than that, because when I got here in '95, it was like 865,000.
Well, and that's
CD districts,
and that's kind of what I'm getting to. I seem to recall at that time we were so small. I seem to recall the entirety of the Supreme Court being present for the swearing in, but that I don't have an independent recall of. I can tell you this: when I started practicing so long ago that it was really a cool place to practice law. And what I mean by that is we were such a small bar that you got to know everyone. If not personally, you got to know one another in passing, just from going to court, going to different functions. Yeah. Of course, jump forward 32 years. I tease attorneys that appear before me right now, because one of the first things I ask them to do is state their appearance. And in stating your appearance, you always have to give your bar number. And man, we're up to 16, 17. My bar number is 4612. Okay, oh, wow. We're up to 60. Now, I'm not going to tell you the number of bar numbers actually confirms the number of attorneys in the state, because I don't know exactly how they assign them. But I'm pretty sure after I started practicing, they follow it sequentially. So that just tells you, of course, the state's seen a lot of growth. Clark County's seen a lot of growth. So I guess it runs concurrently with saying we have a lot of growth in attorneys also. I'll give you another example, Steve. When I moved to town, this is the truth. When I moved to town, we had 15 district court judges. That was including family and juvenile.
And they were together. They didn't change until 93?
The only thing that was separated, we had the juvenile campus, which was at Pecos and Bonanza, which is where they built the family courthouse. And back then, I want to say it was Department 15 judge. In any event, we had one judge that was designated to handle the entirety of the juvenile calendar. But the district court judges all had concurrent, and I'm going to say all because I think they all did back then. Yeah, most of them actually had family court calendars.
And civil and criminal.
And criminal, yeah. So it's everything. And then about it was probably 1992, maybe 1993 that we elected our first family court bench. Mm-hmm. And at that time it was 6.
It was 93.
It was 93 because they started, I don't know if you remember, we had like that second floor over at the courthouse downtown. This is way before they built the RJC, but they had put in 6, I'm going to call them temporary courtrooms, for lack of a better word. I'm almost sure. I remember it being on the second floor, and then they started the construction of the family courthouse downtown. And I don't remember. The family courthouse downtown must have been done, I'm sorry, when I say downtown, Pecos and Bonanza, must have been done about 1994 or 1995.
You guys need a new building.
The building... as you get older, you don't realize how much time is flying. To me, when I moved to town, the building where my chambers and courtrooms at right now wasn't even built. Mm-hmm. So I don't look at it as being that old. But when I step back and look at it objectively, the building's probably near 30 years old now. And to be honest with you, we've outsized the building. We've outgrown the building quite a bit. So yeah, I'm 58. Who knows if I'll live to see. I hear ultimately the plan was to have like I'm going to call it Twin Towers. Have another tower down at the RJC, but I don't know the status of that. So yeah. So I've been in. The answer to your question is I've been in town a long time. That's me personally. Mom and dad were good middle class people. I like to think they taught us right from wrong, and more importantly, they imposed right from wrong. That's kind of how I treat my kids. That's kind of how I treat the people that appear me in court. I like to say with my father, and he told us this: the game of life was not baseball. Okay, and what I mean, how he explained that to us, we did not get 3 strikes in my household. Okay, you were told something once when you violated. There was a very clear delineated consequence to violating a rule. Right. You didn't get 3 chances.
It's funny you say that because that reminds me of my dad. I remember, when you start to get in your early teens, you think you can question things. And so I'm like about 14 and I'm like, hey, well, Dad, how come I have to do that? And he just basically looked at me and said, because I'm Dad. And that was it. And there was no more questions. So if I would say, hey, why do we need to do this? And he's like, because I'm Dad. That was the end of the conversation right there.
The other saying my dad used to use, and that is at his funeral, I spoke and I took my hat off to my mom. My dad used to tell us, this household is not a democracy. Okay, it's your mother and I that make decisions. And he used to use a phrase, and I hope I don't offend anybody. My dad used to say the crap goes downhill. Okay, it always rolls downhill. And he said, in our family, somebody's got to be responsible for dealing with the crap that goes downhill. And he said, in our family, that's me. And because it's me, you are going to follow my rules, because if I got to deal with the crap, it's going to be based upon you following my rules. So yeah, it was cool. I look back on my childhood. We didn't have a lot. We took a little family vacation here and there, but we always had a meal on the table. We always had a good a roof, a secure place to stay, transportation. They did the best they possibly could, and I think they did a pretty good job. Yeah. So yeah.
Please continue.
So
family.
Yeah. I have 3 children, 28, 26, and 20. My 26-year-old is my daughter. She's now a practicing attorney. Well, she's in San Diego. And when I say practicing attorney, and this is not a knock against California, but my daughter actually passed the bar exam. She took the bar exam last February. She found out she passed in July. They have still not completed, although we think they're close to completing the process, whatever checks they do, which was ironic. I didn't know that existed in California, because when I took the bar exam in Nevada, that seemed to have all been done in advance of them allowing you to sit for the bar exam. So when I say she's a practicing attorney, she's working for a firm in San Diego right now. That kind of she's the only of my 3 that's married. She married a guy from California. Dad kind of was hoping that she'd kind of come into practice here in Nevada, but they all have to make their own decisions and for what's right for them, But I have a 28, a 26, and a 20-year.
Okay. And you took the bench. How?
I took the bench. I was appointed by Governor Lombardo. I probably got the call. As a matter of fact, I can tell you pretty much. I was actually in the car with my mom and one of my best friends in Louisiana. We had gone fishing when the governor called, and it was a pretty cool experience because my mom was there, mm-hmm. and she got to actually hear the call. And I can tell you that was approximately March 13th or 14th, because I specifically remembering the governor saying, "How soon can you start?" And I said, "Well, I can start pretty soon. I had to shut down a practice." And I'll never forget. I said, "Well, how soon would you like me to start?" And he said, "Well, if you could start in 2 weeks, that would be great." I'm going, 2 weeks? But, I made accommodations, and I was able to start 2 weeks after that phone call. And what I did, and I think this really helped me out, I'm not going to tell you I took a week, but the week before I started, I took time to go in, meet staff, familiarize myself with the systems. we deal with a lot of crossover systems. You have the juvenile system, you have the guardianships that you have the domestic system, you have civil files, you have criminal files, and I thought it was important. First off, for me, I wasn't worried about hitting the ground running from a courtroom perspective. I mean, hell, that's what I did for 30 years. I knew I would feel comfortable there. What I was concerned with was familiarizing myself with the different systems that were available to be able to look at crossover stuff. And I put a couple of days into that the week before. And of course, I prepared my first week's calendar, and I went in there on the first day, and I held a full calendar. But that kind of comes second nature. The courtroom stuff comes second nature to me. I mean, I tried enough cases where ruling on evidentiary objections, it's like that. I put on enough cases where, particularly when you have better attorneys, you read briefs, and that's what I try to do. I try to prepare my docket, and I think the attorneys are really starting to appreciate this. When you come in, today's perfect example. I had an attorney submitted a 30-page pleading. I try to give them an indication of my knowledge based upon my review of the file, and I try to let them know that you don't have to review 30 pages. And I read the stuff. It's what I enjoy doing. Nobody will ever call me lazy, that's for sure. I enjoy working. So that's kind of how we progress. We progress from my appointment in mid-March to my taking the bench I think I took the bench on March 27th. I think was my first day. To my taking the bench on March 27th to today, is today the 1st? So I guess I've been on the bench 10 months now.
Okay. So
couldn't even tell you how many cases I've tried so far. I've tried a lot.
Have you ever ran for office before?
I ran in 2010.
That's what I thought.
Yeah. 2010.
What did you run for?
I ran for Family Court Department L. Okay. I know this sounds crazy. I have a lot of attorneys won't touch it with it. I have a love of family work. I find it fascinating. It's absolutely fascinating to me. The who, what, when, how, why, where, the psychological aspect of why people do what they do, when they do, how they do, to someone that they obviously had strong feelings for at one time is fascinating to me. I'm gonna write books.
One of my favorite subjects.
I'm gonna write books on this when I'm formally done.
So, and I wanted to delve into this because, and Steve knows this, and Steve and I have talked about this a lot, and we've actually had shows around it. So now that you've went through the appointment process, what's your feelings on the current? Well, it's state law right now that judges are to be elected, not appointed.
I get asked that question. Asked that question.
So, and frequently. I know it would be easy for you as a judge, the current judge, to say that, okay, well, it's state law that judges are supposed to be elected first, right? Except for, there are occasions where they need to be appointed. But since you went through the appointment process, I've been a big fan of appointing judges and then retention. What's your feeling?
The reality of the situation is I'm not the grand poobah, so I have to go with what it is.
Right, yeah.
If you're going to ask me my honest opinion on what provides the best bench, you said something earlier in speaking to your viewers. Find out what's going on. Learn about these issues. Yeah, exactly. Okay? Now stop. That applies even more so to judges. There aren't a lot of resources that the voters of Clark County, the voters of any state can go to find a lot of information about judges or people that are running for judge. Okay, that's the reality of the situation. So you raise a very, very valid point. Find out what's going on before you go into the voter's box. That's even more so with regards to judges. I'll make a statement. I think if people that know nothing about judges go in November and vote for the most qualified judge in my race, I win hands down. Okay? I practiced law 32, well, I've been on the bench here. I practiced law 31 years. I tried hundreds and hundreds and hundreds of cases. So I went, but people don't know that. So people go into the booth with a lack of a lot of people go into the booth with a lack of an understanding of what we actually do as family court judges, and they certainly go into a booth with a lack of knowledge and understanding of the candidates for the. So if you're going to ask me, what's the best process? I don't think the process that we have in the state of Nevada results in us having the most qualified bench, but that's my opinion. I still have to go. If you're going to ask me what I think, if I was the grand poobah and what I would look at to get your most qualified bench, you probably hit the nail on the head. The application process to be appointed was really a cool process. It was a fascinating process. You submit, you have to. It's a lengthy application. If a potential applicant is not willing to put, it took a lot of time to do this application, okay? And from there, you go into an interview process where you have, and I got to be honest, I didn't look to see how they picked the 9 people. The chief of the Supreme Court was the primary person conducting the other process. You had 8 attorneys, and I think there's some provision where attorneys are pulled from different parts of the state. But I didn't look into that before I went in. I just went through the process. The interview process was interesting. It was very, very interesting. From that point, the interview committee selects 3. Those packages are forwarded on to the governor's office, and then the governor conducts interviews before he makes a decision. So if you're asking me what I think the best process would be, having gone through the application process, I got to tell you, I think the appointment. I went to this was really interesting. I was required to go to Judicial College up in Reno, and the week that I was there, we had over 100. We had like 105 judges from. It was like 38 states in Guam, and just listening to the various states' different processes to either elect and or appoint judges. I'm a believer that if you have an application and selection process with a retention election, I think that if you're going to ask me what I think would be the best process, I think that would be the best process. But I live here in the state of Nevada, so I go, and in our state, we have clear direction that when you're appointed by the governor, you have to run for retention the next election cycle. And that's what I'm in now. Somebody filed against me last minute, so I have to run.
And then you're going to have the run in 2026.
That's the only. Steve, look, when I applied for this position, I realized there would be approximately 4 years left on the term. I realized that with that 4 years left on the term, I would have to run. In my mind, I'm thinking, who in their right mind would put their name on the ballot in the 2024 year, who would put in the time, attention, and money that it takes to do this, knowing that you have to turn around and do it again in 2026? Okay? So from my perspective, I understood there was the potential to have to run against somebody in 2024. Did I think the probability, it was more likely than not that would happen? I got to be honest, I thought it would more likely not happen, but it's happened, and I got to live with it, and I got to go with it.
And I just want to put a disclaimer: if you see me get up and leave, that means I drank too much water.
So I hope that answers your question.
Oh, yeah, it does. And like I said, that's always a difficult question to ask, because state law says that, judges are to be elected in the state of Nevada, and I have a personal view about that one way or the other. I think in some aspects, I think electing judges is good, but at the same time, I get frustrated with individuals that won't, and I'm one of them, by the way. Steve has been tremendous on making me focus on judicial candidates. Like he's been really good about that. So now I get frustrated that people don't do their due diligence when it comes to vote. But I always ask that question of judges.
Can I add one other thing? I sort of became friends with a guy. He's out of not Massachusetts. In any event, their state was really interesting. I don't know if I would go this far. I don't know if this is the right way to do it. They go through an interview and appointment process. It's a life appointment, only subject to a negative retention ballot. Now I don't know if I would go that
Yeah,
that's almost like federal. I don't know if I would go that far.
Yeah.
I think you have to have some, but yeah, I think that if you're looking for the most qualified bench,
Right.
and I think ultimately, I if I wasn't an attorney, if I was a layperson going into court needing an issue resolved, I would like to have the confidence of knowing that I'm going to have the most qualified people hear my issues. But when you come to life appointment for a state position, I don't know about that.
Life appointments.
Kind of
I've always been a little uncomfortable with them. Okay, so I hate to steal this question from Steve. This is one that he usually asks. I'm going to ask it, and he can follow up. So, as it comes to, and I'm looking for this answer based on just as a judge. Okay, what are your favorite amendments? And it could be any of the there's 27.
The Constitution.
Yeah,
the Constitution. You're talking about federal constitutional amendments.
Yep.
Bear arms. I really, of course, I appreciate free speech.
One.
Yeah, but bear arms. I think that's very, very important for us as Americans.
All right.
So my favorite. Okay.
So what I was thinking about as a family court judge, there's two particular amendments that I think of, like the family court, not necessarily the judges, but the family court division in general have been forgetting about is the Sixth Amendment, which is the right to an impartial trial, okay, or jury trial. And
jury
trial
is the seventh.
But you got to understand, we have state law that directs some of that too.
Right.
The state of Nevada, in a domestic case, we have no provision for jury trial. Okay, so I'm going to be honest. I wish we did. I enjoyed putting on jury trials as an attorney. I would really enjoy.
That's the answer I was looking for.
They say. Now, as a judge, I haven't had the chance to put on a jury trial, okay, but I put them on as an attorney.
Right.
But judges that I've spoken to in different conferences, what we do at family court is we put on bench trials, okay? So I'm not only the judge, I'm the finder of fact, which means I have to be very keen to all of the testimony, all of the exhibits, because ultimately I am the one that's making the decision. When you're dealing with a jury trial, now once again, I'm talking competent attorneys that are crossing their T's and dotting their I's.
Right.
When you're dealing with a jury trial, the jury is the determiner of the fact, okay? All the judge is really doing is making sure things are being put on in the of course, you have to make succinct rulings on objections, okay? But you can, what we do at the family court requires, it requires 100% focus and actually 110% focus. So,
well, I think, and I probably worded the question wrong, but the thing that frustrates me about family court is that, well, it's kind of two sides, right? Like I get frustrated. I think the Nevada legislature has went too far in handcuffing judges on civil and criminal cases outside of the family division, and like they dictate like, okay, this is what the mandatory sentence is for this crime, that crime. So there's no discretion allowed, or not no, but limited discretion on the part of the judge.
There's still some discretion,
right? But the family court division, it seems to me completely opposite.
What do you
it's
mean?
Almost like the family court judges like have full discretion.
Yeah,
they can pretty much do whatever the hell they wanted. Excuse my language.
Well, let's take something a custody case. Okay, we have case direction, statutory direction on factors that we have to consider in a custody case. You can apply the same to child support. We have factors that we need to consider. We have direction on how to take. Alimony. We have alimony. We don't have a statutory formula. We have stated factors that we're to consider. So there is, but yeah, I agree with you. There's a ton of discretion as to how we apply the facts to to the statutory authority, the case authority, the factors that we are to consider. Yeah, we have a lot of discretion. I used to tell as an attorney who consulted with clients, and let's just throw an issue out there, but this is the truth. Let's take an issue like spousal support, alimony. I used to tell clients when they would come in, you can interview 20 different attorneys and 20 different judges on, let's just focus on that issue, on amount of alimony. First off, whether it's applicable, amount, and length. You will get 40 different answers. You're going to get 40 different answers. The legislature has tried to tie, let's take another issue like child support. You should get a lot less different answers, but the judges still have factors that we can look at to make deviations from the statutory percentages. It comes to custody. And it actually started in the Supreme Court. The Supreme Court tried to give us some direction. The legislature has taken the mandate or the direction of the Supreme Court. But yeah, there's factors. So yeah, there's a lot of discretion allowed to us as family court judges. Now, I disagree with something you said from a sentencing perspective. I think the federal court system, the judges have even less discretion than the state court system from a pure sentencing perspective. We don't have, I mean, those federal sentencing guidelines are
right. Yeah. Yeah.
I don't want to say written in stone, but
right.
they give federal court judges, I really think state court judges in criminal cases have more leeway than federal court judges.
Yeah. So let me ask you, do you think that, let's see, and here's something, and this is more just like for my information and for the viewers and listeners. Do you think there's something wrong with, like, where do you think the checks and balances come in with where do you think the legislature kind of, they're going too far on certain stuff because as far as what they can do as far as telling the judicial branch, like, these are the minimum sentences, because I mean, even though the judicial branch and the legislative branch are co-equal branches of government, but they have different roles, though.
Yeah, but the legislature's role is to establish establish the codification of law. Okay, right. So the legislature gives those parameters, maximum, minimum. Okay. Then the judge has the discretion to go towards the maximum, towards the minimum, or somewhere in between. Look, my job as a judge is not to write the law. That is the legislature's job. My job as a judge is to take the law as it exists, statutorily and common law by way of cases, and gather an understanding of the law, apply the law as I understand it to the facts as presented to me in the case. Okay, so the legislative branch is different from the judicial branch. And that's just that's the way it's got to be. My job as a judge, our jobs as judges is not to write the law. That's why you guys as voters elect your legislators. Okay, they are the ones that are responsible for getting in, caucusing over right versus wrong, taking evidence pertaining to modifications of statutes, amendments to statutes, implementation of new statutes. I got to tell you, as a judge, as an attorney, sometimes I would look at a statute and I go, where are they coming from with this? Okay. But then you delve a little deeper into it, and you can get into the legislative history behind the statute. You can get into testimony and they call it testimony. You can get into information that they considered in arriving at the statutory framework. Now, sometimes you still step back and you scratch your head, but sometimes you can understand what they're doing. I'm going to be honest. My position as an attorney and my position as a judge, I think, but this doesn't just apply to Nevada. This applies to our country as a whole. I think we've gone almost too far with the implementation of statutes. I mean, there just comes a point where we have so much. I'm going to refer to it as new law being established from a statutory perspective. There's an old saying: the left hand's got to know what the right hand's doing. And when you have a law over here saying A, and and nobody's even considered the law over here is saying Z, and how there could be a conflict between those laws. Look, I don't know. Sometimes it's daunting when you sit down and you start looking at everything that's there. I mean, we now have chapters of the Nevada Revised statutes that have an A, B, and C section. And I'm not saying there's anything wrong with that. I'm just giving you an indication as to how far we've come in promulgating additional statutes.
I've often said, like, okay, let's not write new law. Let's just apply what we have right now and make that work, and then we can look at writing another law.
Sorry, I want to clarify. I want to clarify something because I was. This is probably the longest.
Were you in the bathroom?
This is probably the longest I've ever stayed silent.
Yeah.
But I want to. Jim brought up the Seventh Amendment, which is the right to a jury trial, and you brought up state law. Do you think state law should trump federal law?
Or
because state law constitute the right to a jury trial.
It's interesting. Of course, we have the 14th Amendment also,
which is the right for fair judiciary.
State law. I haven't really thought let's just say you're dealing with a federal issue. Mm-hmm. Okay, it would be my position that state law should, of course, never trump a federal law on a federal issue. Mm-hmm. But I don't think that's the question you're asking. I think the question you're asking is whether federal law should trump a state issue. Okay. I believe from a federal law perspective, and I think if you go back to the Constitution, mm-hmm. a lot of issues were intended to be deferred to the states. Mm-hmm. Okay. I think, and I've always been a big proponent of this, I think competition amongst states is a good thing, okay? Because if the populace believes that state A are doing things better than state B, state A is going to become a stronger state based upon their. So I don't think now you got to be careful on that, because if you're dealing with state issues where, and I'm trying to think of an example as I say this. If you're dealing with state issues that are concurrent with federal issues, I think at that point in time, the federal law has to trump the state law. But then again, you're talking about a legislative issue, because why would the state legislature adopt a law that's contrary to...
They adopt so many laws that are in conflict with the Constitution. It's incredible.
But you notice I said why. I mean, so that's where you got to step back. But I do believe that the founders' intention, and I say this confidently, was to defer a lot of these issues to the state level. Yeah, absolutely.
So that's the 10th Amendment.
So the Constitution says that you have a right to a jury, okay? And when I look at family court and I see cases like relocation or termination of parental rights, I really don't think that one person should make that decision that's going to affect an entire family or families for generation on. Because I've seen kids go to Australia, I've seen kids go to New York, and the other parent hardly ever able to see that child. I've seen judges terminate parental rights just because they didn't. I mean, they listen to the caseworker sometimes, and sometimes the caseworker misspeaks and fib. And I've seen when kids are taken away from parents in termination, sometimes the judge don't like plaintiff A or defendant B for whatever reason. Yeah. And I've seen it. And I don't think that one person should make that determination to say, you can never see your kid again.
Well, because I had an interesting issue. This is about 20, 25 years ago. And I don't know the specific answer to this issue. There was a judge in Clark County, and I had a termination case which had a corresponding guardianship case. It was a mess. It involved a child that had been taken to this country from Iraq to get her away from the war and all that stuff. Mm-hmm. But the judge in this case, and he was gung-ho, he wanted to put on a jury trial. I don't know if you know this. At the family court, we have one courtroom that's set up to put on jury trials.
Which courtroom is that?
It would be the first, as you come up the stairs, okay. You go to the
left or right.
You go to the right. The jury box is still in there. I just met for a CASA swearing in, and we had people sitting in the jury box.
Whose courtroom is that?
Right now, I don't. Right now, it's a juvenile courtroom. It's Judge Gibson's courtroom, if I'm not mistaken. But allow me to get what I was saying. He had actually said. Now we never went forward on the case, okay? But he had actually said, and I don't recall what portion of the case it was. He had set for a jury trial. I don't remember if it was the termination portion or the guardianship portion, but he seemed to believe that the Nevada authority limiting the right to a jury trial pertained only to what I'm going to refer to as domestic cases. Mm-hmm. But to sit here right now and give you a definitive answer to that, I can't tell you I can give you a definitive answer. Now I want to comment on the termination cases. Steve, I can tell you, and I say this sincerely. I said this as an attorney. It's hard to use that EST, okay? But the toughest cases we deal with as judges, and I'm being honest, as attorneys, are termination cases. I don't know if you know this. They've been compared. They've actually been called cases pertaining to the civil death penalty. Is what they've been referred to.
It is civil death.
Well, hold on. There are cases out there where orders terminating parental rights are entered. Of course, there's cases, but I'm going to tell you, and this is something as an attorney I argue many times. As a judge, I look very, very carefully for. I agree with something that you said. There are often conflicts between workers for the division and parents. Workers for the division and grandparents. We see that all the time. So as an attorney, I always try to point those conflicts out. As a judge, I always try to pay very, very...
Do we have a grandparents' rights in the state?
Yes, we have grandparent rights, but the grandparents' rights have been...
Dissolved.
Not dissolved. They're not dissolved. Statutorily, it's still there. But the right... I'm going to put it to you this way. I believe grandparental rights from the time that I first started practicing law here in Clark County 30 years ago have diminished quite a bit over 30 years.
Almost non-existent.
But hold on. I want to get back to termination. We have as a judge, I have to make very, very specific findings of what I'm going to call very bad behavior.
That happens.
Oh yeah, it does happen, absolutely. In the old days, we referred to them as jurisdictional versus the dispositional grounds. Now we don't really use those terms anymore. Now we're really looking at fault because that's what most of the statutory factors are: fault-based versus best interest of the child. So both have to be involved. But I mean,
let me. What does that mean anymore? Best interest of the child, because I think it kind of lost its zest.
Well, I used to tell people all the time, if you ask 100 different people,
you get 100.
You get 100 different answers. But the legislature tried to give us some direction. I don't know if you guys have looked at the statute. Yeah. We actually have. That's where I got to those factors a little while ago. We have factors. They're very amorphous, to be honest with you. So the best interest of the child boils down to an individual interpretation as to what's in a child's best interest. These are cases we struggle with all the time. The request to terminate parental rights, the request to terminate parental rights when there is not, number one, a potential step-parent adoption in place for the child, or number two, not a step-parent adoption, but another adoption in place. I'm going to give you an example, and we see this all the time. Let's say a poor kid's been in the system. Well, let's say the kid's 13 years old and he or she's been in the system for 10 years. Okay, the biological parents have been provided case plan after case plan after case plan, and it becomes pretty apparent.
You term out after 18.
Yeah, 18. But right now 13. Just hear me out, because you'll see where I'm going with this. Okay, this is the kind of question we have to answer as judges. It becomes apparent that the parent, for whatever reasons, those fault reasons that we were discussing, is not going to be able to correct a situation where he and she can serve the best interests of this child. But then I, as a judge, I have to value the best interests of the child also. I use the word bastardize. I don't know if that's really the right word. But in terminating the biological parent's rights and effectively bastardizing, freeing the child for adoption, where there's no adoptive placement for that child. And we know statistically that a 13 to 17-year-old, they fall into those cracks when it comes to adoption. Okay, does that serve that child's best interest? I mean, that's the kind of hard questions that we got to deal with. Trust me, if anybody tells you termination cases are easy, they are not easy. Hear me out. I've now been on the bench for, it's a little short of a year. I told you earlier, I can't even tell you, I've tried a ton of cases, okay? I enjoy trying cases. I've only had 2 or 3 cases that I've gone home on and I've had trouble sleeping, okay? And 2 of those cases were termination cases. Okay, they're just tough, man. They're tough cases to decide.
Judge, do you think that one person should make that decision when it comes to termination?
If you're asking me whether that would be better before a jury, is that the question?
Or a tribunal? Because I was trying to get legislators to look into that.
When you say tribunal,
like a 3-panel,
like a 3-person panel.
Yeah, right. Yeah. And all 3 of them could be, good judges. Or a couple of attorneys.
Maybe you put a non-judge on. I've never thought of a panel. I've never really given that consideration. I think if you're going to do it by way of jury, okay, we got to start from a basic premise. Do we treat it, and I don't know if you guys have considered burdens of proof, okay? But I think you know what I'm talking about. In a criminal case, we're talking beyond a reasonable doubt. In a civil case, we're talking a preponderance of the evidence. Right. In a termination case, we're talking something a little different. It's clear and convincing evidence, okay? Right. It falls somewhere between. Right. It's more than a preponderance, is less than beyond. In the state of Nevada, in a criminal case, you're entitled to a jury of 12. In a civil case, you're entitled to a jury of 8. In a criminal case,
I thought it was 7.
It's 8. Yeah, but hold on, let me finish. That criminal case, you have to have all 12 rules. Civil case is 3/4. That's where you get in the odd numbers. So 6 of 8 can decide for plaintiff, defendant, win, lose. I guess we'd have to come up with a structure. First off, would the civil jury burden apply, or would the criminal jury burden apply? Would we use 12? Would we use 6? Would we need a unanimous verdict? Would we do 6 out of 8? And to be honest with you, that's the first time the question's ever been posed to me, so I haven't sat down to think about that question. Look, if you want to make my job a lot easier and take those tough decisions away from me,
and I'm not speaking for Steve here, but I think to just kind of piggyback on what I think Steve's intent to his question is because unfortunately, and this is my opinion, this is not Steve's opinion. Steve can speak for himself. But one of the things that I have noticed, and I'm not a parent myself, so I'm kind of like just speaking off perception here, not something I've had to go through. But being a co-host on the show for a number of years, we've interviewed a lot of family court litigants that have been on, and pro se litigants, and I've heard horror stories about some of them, and some of them are like because they didn't get the decision they wanted, right?
Hold your thought, because I do want to make a statement.
Yeah.
Remember that when you interview an individual litigant,
Yeah.
that litigant, it's tough for that litigant to be objective.
Right. And I was getting to that.
When I was an attorney, I would get calls from buddies whose buddies were just shafted. And when I sit down and look at the file.
But yeah, hold on. I get it. Hold on a second, Judge. I was getting to that because I'm like, that happens whether it's a family court case or any case. Yeah. If the judge rules against you, it was a horrible decision. Like, okay, so we understand that. But what I'm getting to is like, as far as like just seeing so many examples of judges being so, in family court in particular, just being so biased one way or the other because, they know the attorney and well, you have to get a drug test and but you can only get drug tested by this individual. You need to get therapy. Well, you can only go to this person for therapy. And it's this almost like Jim Crow, like good old boy system going on. I think that's where where the frustration comes in is like
as a practicing attorney and now as a judge, it's one of the problems that I have with the system. I think we've created, I'm going to use the phrase, a couple of cottage industries down there.
Right.
Okay. Yeah. So agree or disagree, this has been Judge Gaudet's philosophy and practice since the day I took bench. And I tell the attorneys, okay, I am the judge. Ultimately, it is my responsibility to make a determination. And right now we're talking about custody as to what's in a child's best interest. So if you are going to come before me requesting me and what we typically call it is a child custody evaluation. If you're going to come to me requesting that I send you out for a child custody evaluation, the answer is no. Now, if there's a stipulation, I'm not going to disagree with two litigants' stipulation. Oh yeah, it's required. But what I'm getting to is we've created this industry where we send people out to quote unquote specialists, and when people get involved in this, and this is one of the gripes of the system, okay. Once you get sent to these custody evaluators, trust me, you are never talking less than $5,000. And in most situations, you're talking $10,000, $15,000, $20,000. Okay? For what? For me to get a report saying that it's somebody else's opinion that this is best for the child. Ultimately, I took on the responsibility of being a family court judge. Ultimately, it is my responsibility to evaluate the facts of the case. And this is something we see all the time. Man, one person doesn't agree with what that evaluator's saying, and it turns into... So I've developed...
Hours and hours of it.
Oh, man, crazy. I'm talking 100... It's just... hold on. This is the position that I take. I have to determine what the relevant facts are and how they apply to the best interest. Let's just put it on before me. Okay. Instead of, and by the way, we're talking months and months and months and months. It's just crazy to me. So and whether I'm the exception or the rule, I don't know. I don't know what the other judges are doing. It's my courtroom. It's discretion. I do what I want to do. But I think my way. I feel confident in saying my way is an efficient and cost-effective way, because boy, that was one of the gripes.
But is it a constitutional way,
though? I think my way is certainly constitutional because I'm the one that's hearing. I don't defer my response. You made a comment with regards to termination of parental rights and the division. That's what, as an attorney, you don't know this. I tried over 100. I think I'm saying I probably tried 100.
I watched some of your cases.
100 of these termination cases, and one of the gripes that I had all the time, we have judges that are quote unquote juvenile judges. Well, what happens is you have the same caseworkers coming in, you have the same attorneys coming in, and I'm not saying that there is favoritism. but it gives the appearance. We as judges, we have to give the appearance of independence. Right. Okay, that's got to be there, and that's why I said I question those things that we covered, because I'm not going to rubber stamp somebody else's findings. That's not my job. My job is to get in there and I'm not saying make a determination of who's absolutely right and who's absolutely wrong. But my job is to make a determination as to what the operative facts are. And I don't defer. I don't believe in deferring that responsibility.
And why can't the litigants use their insurance to go to these specialties? What is the court telling them they have to go to this person, that person, this person?
Well, I can't answer that question. I can tell you, I'm not big on referring people for therapy and evaluations. I've already said that. I had somebody stipulate, it was one day this week, stipulating in court to utilize a therapist. What I do, okay, I give, because I don't want to be the judge that's creating this cottage industry, okay? I don't want to start referring. I don't refer anybody to anyone to anybody. That's not my job. So I don't think that's my job. This therapy was stipulated to between the parties. Okay. So what I do is I say, first off, we have insurance coverage available. Let's try and minimize. Now you got to watch it. Yeah, but you got to watch the language you use, because sometimes the insurance will kick it back as uncovered. But what I do is I take one of the parties. I don't care if it's mom, dad, the grandmother, if they're involved, and I say, this is what we're going to do within a relatively short period of time. Let's say 48 hours. You're going to determine who's available under the coverage. We're going to have one side select 3 names, send it to the other side, and then the other side picks one of the 3. That way, Judge Gaudet didn't send business to anybody, okay? Because
good for you.
And that's
exactly what I want to hear.
But as an attorney, that's how I felt. I think we are supposed to maintain our objectivity. And if we get stuck in a rut where we are referring business to certain and
people are going to wonder what's your take.
In my opinion, it's just wrong. But you can business valuations, right. Okay? That's important in these cases, yeah. Okay? But Judge Gaudet ain't going to tell you which business valuator to use. Either you guys stipulate to. I had an attorney ask a very relevant question the other. They had actually stipulated to a valuator. First off, when that valuation comes back before me, I have the right to question the valuation. I don't have to accept that figure. So he asked me a question that was very relevant. Hey, Judge, we are going to use Joe Blow, but I just want your opinion. Regardless of where Joe Blow comes in, I'm still going to have the right to challenge Joe Blow. Absolutely, you have the right to challenge Joe Blow's numbers. So Joe Blow is giving me like a blueprint, in valuations. I want to see the 3 methods for valuation. I want to see what was put in. I tried a case 2 months ago. The valuator didn't even utilize one of the 3 methods for valuation. Push comes to shove. I totally disagree.
And the evaluator could be biased.
I've had child custody. This happened in another case since I took the bench. This was before I took the bench. They had stipulated to a child custody evaluator. Well, the report comes back, and I think it was the father in this case. He's feeling uncomfortable. So now they're filing motions to have another evaluator appointed. And they come in on the motion. I said from the bench, you guys do understand I'm the judge. I determine the facts. And simply because there's an opinion doesn't mean I got to follow the opinion. You talk about jury trials. We have a jury instruction that says, ladies and gentlemen of the jury, this person testified as, and I'm paraphrasing, as an expert because of their qualifications in the field. You treat them like any other witness. You have the right to value their testimony as you do. And that, in a couple of cases that I've tried, I actually state that because these attorneys are, you got to accept the position. No, I don't. I don't have to accept that. And that's why I think when they go off to these child custody evaluations and spend $25,000, $30,000, $40,000, I don't know.
You break them.
You break them. You're putting them in a position. Not only that, when you put people through this evaluation process,
that's not even the best interest of the child, because you're taking money away from the child when you
the
do
parents. This is where I believe it's really it's contradictory to the best interest of the child. The longer we promote this in family court, the longer these cases go on. The longer these cases go on, the more detriment we cause to children.
Isn't it statutory supposed to go on for 6 months?
That's statutory. We have direction from the Supreme Court. These things are supposed to be done. Now,
Years.
Hold on.
Cases.
Do you see the problem I have with the child custody evaluations? Some of them, the first or second week I took the bench, they had stipulated to this before I came in. I said, okay, y'all stipulated to it. I'm not going to tell you, who you're using. Well, we want to use Joe Blow, but she can't get the parties in for 4 months. Time out. So my case is supposed to sit for 4 months when you guys could be bringing evidence. So I come up with a solution. Let me give you a trial date in 45 days. Bring them in, have them testify, and see if we can. Oh, no, Judge, we want the, So I don't know. The answer to your question is we are supposed to endeavor to resolve child custody issues within 6 months, and that's what I try.
And I see these things go from birth to teenage years.
There's other things, yeah, but you once again, you got to look at what they're telling you. Okay,
but then sometimes you get litigants that keep coming every 5 months,
and that's the point that I was going to make.
Yeah,
a child custody order cannot be written in stone, and what I mean by that, we're dealing with the best interests of a child. And things can always happen in a parent's life. So a lot of these cases that you're hearing that they've been there for 10, 12 years, yes, but that's because of the conflict of the parents. We refer to those as high conflict cases. It's a small percentage of it. I would venture to say, Steve, it's amazing. When I get set to prepare a case, my clerk briefs it. I look at the brief, and right away I got where I can go back and look at the pleadings. Okay. And you can tell high conflict cases because when I go into the domestic section, there's not 100 pleadings. There's not 150 pleadings. Sometimes there's 7, 8, 900. When I see that I'm on pleading 999, when I was, oh my goodness, this has been here a long, long time. So be careful. When they tell you they've been before the system 3 or 4 years, it could be them going back and back and back. That's resulting in them.
Judge Gaudet, could you explain a vexatious litigant?
Yeah, a vexatious litigant is someone that continues to file motions with the court, bringing the other person back to the attention of the court, typically involving the same or similar issues.
Does it, and then the court deems the court. All right, so okay, let me rephrase this. So if the court deems somebody vexatious, what does the court do to that person?
Okay, the court has the power to sanction that person, typically monetarily, but the court also has the power to restrict that person's ability from continuing with the same course of conduct. I'm going to give you a very simple example. And this works, okay? Now you have to have a hearing. You have to make specific findings to find someone to be a vexatious litigant. But once you find that person to be a vexatious litigant, I had a judge do this a number of years ago, and I saw how productive it was. And I've kind of tried to adopt the same philosophy because I think it helps. The judge has the right to say, hey, look, you've been vexatious. You keep doing the same thing. We're going to enter an order that says you no longer have the right to file an order. To file a motion. And the clerk is not allowed to accept any filed motions without you in advance submitting that proposed motion to chambers so that we can review it to see whether or not there's a legitimate basis to bring it. Okay. If we deem that you are doing the same thing, we will not allow you to file the motion. If it's something that's relevant, and once again, these vexatious, they tend to focus on the same issue over and over and over.
Does it go against the Constitution, like the 14th Amendment, right to a fair judiciary, if a litigant feels they're handcuffed and they can't defend themselves, especially pro se litigants who is acting as their own attorney?
Yeah, but if you're acting as your own attorney, you still have to be. I tell people this. I'm going to give you an example. What you do for a living right here, you do way better than me. Okay. When I was an attorney, I was a way better attorney than you. But if you come into court representing yourself, I have to hold you to the same standard. Yeah, we have to. The answer to your question is you're dealing with a person's constitutional right to bring issues before the court, but you're dealing with the court's obligation to efficiently administer justice. Okay, so that's where the conflict comes in. I can tell you, in the state of Nevada, we give courts the right to determine to efficiently manage their dockets. And Steve, man, you got to. It sounds like you got to remember what goes on in that family court, man. That family court. If you don't sit in there for years, if you don't, that's why I tell people all the time. I used to do this with my kids. I used to say, well, Dad may not be the brightest bulb in the Christmas tree, but he's reasonably intelligent. I would get the roll of the eyes. Okay. But I tell them that. But one thing I am is decisive. I'm not pompous enough to say I'm right all the time, but I'm decisive. And then you have appellate rights. I think it's very, very important for judges, particularly in the family, in all courts, but in the family court, it's important to make. I take very few things under advisement. I had a case I tried today. I took under advisement. It's on my mind. But I'm going to have the order written tomorrow. Okay, this isn't something that's going to sit for 2 weeks, 30 days, 60 days, because it's important. A year. That happens too. Because it's important for people to know
to move on with them.
To move on, and not only to move on. If you think the judge is wrong, it's important for you to be able to pursue your next recourse.
So, Judge, let me ask you this real quick, because you got a busy day tomorrow, and I don't want to keep this moving. Okay, so Steve touched on vexatious litigants. I want to touch on, and I liked your answer, and I understood.
Make sure he's done explaining the vexatious. Are you done explaining?
Yeah. Well,
I want to ask about attorneys. How come attorneys aren't ever called out?
Vexatious.
You haven't sat in my courtroom.
Yeah, that's right.
I've never heard an attorney called out as vexatious. Good point.
Well, I can understand somebody that's trying to self-represent, because they're a little shaky on the law, but lawyers tend to do it too.
This is how.
Good point.
This is how I conducted my practice. I had a very good practice that provided very, very well for me. I could have probably made 4 times as much money if I was always honest with people.
Right, so you already answered my last question.
If you as an attorney, the last thing I wanted to do was to get on a ship that was about to sink. Okay, and I think I'm being honest, and I think most attorneys value their reputations, right, and they do that. The majority of the vexatious litigants are pro per litigants,
right?
Okay, because particularly when they're dealing with a pro per on the other side. Okay, if they're dealing with a person that's represented by an attorney, that attorney can come before me. I can start awarding attorney's fees. Okay, if they're doing this against a pro per, there's no attorney's fees. There's no consequence to doing this. So I don't see very many vexatious litigants. Look, I tell people it is within my sound discretion to make an award of attorney's fees. I have to make certain findings. I tell people, and look, there's only 2 ways to resolve any dispute. You resolve it by agreement between the parties, or and they laugh when I say this, you let the gray-haired chubby guy on the bench impose his beliefs upon it. Okay, now that's what it boils down to by trial, right? And I tell them, okay, I want you to try and settle this between yourselves, because if you can, it's more palatable. Anybody will tell you when you have input into a settlement, it's easier to live with than when somebody has to tell you what to do. Okay, but it's no problem. I like trying cases. I will try your case. Just understand, one of the factors you have to consider when you go in to try this case, Judge Gaudet is going to have a winner and a loser. Okay, this ain't Solomon. If I have to make a decision on who's telling me the truth and who's lying to me, it will be made. One of you will be deemed to be incredible. Right. Okay, and you're going to be pissed when you leave this courtroom. But once I make those findings, I'm telling you in advance, right, wrong, or indifferent, I'm going to see who was right and who was wrong. And I have the right to enter orders for attorney's fees, okay? And that's how my courtroom's treated.
So
okay?
If, let's say it's opposite, like how Jim says, the attorney's the one that's actually being vexatious, but
we should say FC.
But they're not the pro se is not paying attorney's fees because the pro se gets sanctioned from the attorney for keep bringing the same thing back and forth.
Yeah, the pro se could be sanctioned monetarily. Okay. But then you deal with
the attorney sanctioned to give the pro se money.
Oh, absolutely, absolutely. If an issue is wrongly brought to the attention of the court, Absolutely, sanctions can be issued. Now, I think what you're mentioning there, or the way I just said it, is something that you're more likely to see in the family court. I think you're more likely to see on sporadic occasions attorneys proceed with issues on behalf of a client where the likelihood of success is in question. I don't think you're likely to see attorneys that are vexatious from the definition that I apply to vexation. You know, if you come before me once and I tell you get out as an attorney, I tell you to get out of here. You got to have some serious cojones to come.
Right.
Remember what my dad told me: the game of life is not baseball. Right. Okay.
Yeah. Exactly.
Let's talk about drug use. Okay. So, and the way it has been explained to me, and you correct me if I'm wrong, Judge, that a family court judge is a civil judge. It's not a criminal judge. So only a criminal judge could order a litigant to take a drug test, and if that litigant opposes it and appeals it to the Supreme Court would reverse it.
I disagree with you on there. You see what drug tests are ordered. I've never seen one ordered in a non-child custody case. Okay, we're talking about child. I guess if you're talking about a TPO, but I've never seen that. So drug tests are ordered in custody cases. Mm-hmm. What is the predominant and sole consideration of the court in a custody case? The best interest of the child. Okay, so I think it's clear that we as family court judges have the authority to refer people for drug testing. Okay, that does not mean, because I forget who asked the question, but using other facilities. That doesn't mean you can't go at the same time and use another facility, and then we're possibly dealing with the issue of a dirty test versus a clean test. I mean, for me as a judge, that raises interesting issues. Boy, now I get to set an evidentiary.
And then if a litigant refuses to take the drug test, then the court deems the test dirty.
Yeah.
But I need to go back and check on that, because the way it was explained that a civil judge, which is a family court, as civil judge, don't have a jurisdiction to tell a litigant.
I have never heard that. If there's statutory authority out there for that, it's something that I've never.
Because there's one judge that she's no longer on the bench, but she never ordered anybody to take a drug test because she didn't want it to come back on appeal from the Supreme Court. Because
I'm going to be honest, that's not something. Drug tests are ordered regularly in the family.
I know.
Court. I can't tell you we deal. I don't know what percentage of cases we deal where there's drug allegations, but 10% of the, but I order drug tests.
And what about the rules of evidence? Do you follow the rules of evidence?
I think it's
because everybody's on hearsay when it comes to family court. He was drinking. They was drunk. They're drunk. They were using drugs.
Oh, no, not Judge
But
Gaudet.
no evidence.
I think a domestic case is still a legal case. A custody evidentiary hearing is still a trial. A trial over disposition of assets and debts is still a trial. Absolutely, unequivocally, the rules of evidence apply. But you mentioned something interesting. I just read an article in this, and it's neat. The article was entitled "We're Losing the Hearsay Rule in the United States." Okay. What's happened is both statutorily and from a common law perspective, there has been exception after exception after exception to the hearsay rule. Okay, a legitimate argument can be made based upon every hearsay objection that there is an exception as to why it should come in. Okay. Now I try to look, if someone, Janie said objection, sustained. Okay. Now and it seems like some of the attorneys are prepared to be able to argue exceptions to the hearsay rule. But to answer your question, I am a stickler. The rules of evidence apply. Now, by the same token, to understand one other thing. The job that I have as a family court judge, I've already explained to you that I make factual findings. As a judge, I also am allowed to determine how much weight I place on anything that's said or any document that comes in the evidence. In other words, if it were a jury trial, we got a jury instruction on that too. You guys determine how much weight, but that's when the judge has let it into evidence. Okay. Now I'm the judge. I had this happen in a case this week. I tried because one of the attorneys, the attorney might have moved for the admission of something, and it might have been a pro se litigant that objected. I let it in, and he kind of said, and I looked at him and I said, just because I let it in, I'm the one that determines how much weight is to be placed on it. Okay. So we try to put these trials on in as efficient a manner, at least I do. I try to put these trials on in as efficient a manner as I can. Okay. With that being said, are there times that an objection is made and I understand it's objectionable, but instead of getting into, for lack of a better word, a pissy match on the record as to why, I'll let it in knowing that I'm going to give it very, very, very little credence when I write or make my decision. So does that make sense? But I can tell you this: in Judge Gaudet's courtroom, the rules of evidence apply.
Contempt of court.
Yes.
Who determines a litigant is in contempt of court?
In my court?
In family.
I do.
Okay. Should that same judge?
Two types.
Should that same judge be the one that presides over that hearing?
You're talking about civil contempt versus criminal contempt. There's two different types of contempt.
But a jail cell don't know the difference between a civil contempt.
Oh, no. But the person making the decision knows the difference between those two contempts and knows how to apply the different burden. Hey, look, Steve. The reality of the situation is we have orders in place. If people don't follow orders, first off, if they believe the order is wrong, I've explained there's a process. Okay, I got no problem. I will never hold it against someone for filing a writ against me or filing an appeal. That is the nature of the beast that I deal with. Okay, so you have an available remedy to address the order when you think the order is wrong. Okay, so now let's get beyond that. You have an appeal. The order is in place. If we don't hold people, and right now I'm talking about civil orders, okay? If we don't hold people to following the content of orders, we are creating chaos in society. And I've stated this on the bench. Judge Gaudet will not be accused of creating chaos, okay? My orders will be followed, and there's a consequence to that. Some of the common things that we deal with, child support payments, spouse support payments are very typical. Following through with division of community properties or debts. Now, my philosophy. I had this discussion with a couple last week. Actually, they had attorneys. My philosophy: I don't want to set people up for failure. Okay, and I'm just going to give you that. This came up in this context. They had stipulated to this holiday and vacation plan. It was the most comprehensive thing I'd ever heard in my life. And it was overly comprehensive because when you set two parents up with that many scheduled exchanges, that many interactions between one another, you're setting them up for failure because sooner or later somebody's not going to show up at 5 o'clock or 5:15. The other one's going to sooner or later. Somebody's not going to give, hypothetically, 14 days advance notice of the flight to Mexico. And you're laughing. This is the kind of stuff we deal with. I try not to set people up for failure in that regard. I try to explain that to them. Now, by the same token, if Judge Gaudet has determined the gross monthly incomes of a mom and a dad, and we have a shared physical custodial award, the law is clear on how I calculate child support, in my opinion, clear. Okay, I look at the percentage of one versus the percentage of the other. The higher earner has an obligation to the other. Now, if they leave court and I tell them, okay, I take child support very seriously, please do not make me impose, okay? But if you're going to go out of court and you are not going to comply with something as basic as a hypothetical $350 a month child support obligation, we have to have a remedy in place to enforce the obligation. We have to. But once again, that is a civil contempt proceeding. That's not a criminal contempt proceeding.
Okay, explain it to the civil and the criminal contempt.
A lot of it has to do with
civil contempt. Could you lock somebody up?
Absolutely.
Criminal contempt, could you lock somebody up?
Yes.
What's the difference?
Because on the civil contempt, I am required to give them an ability to purge the contempt. I'll give you an example. This is an easy example. Guy comes before me. By the time I've heard the case, or woman comes before me. By the time I've heard the case, there's 3 months of no, because it takes about 30 days to get a hearing. There's 3 months of no compliance with my child support order. $250 a month times 3 is $750. You're making me do something I don't want to do. Okay, I have the power to sanction you monetarily. Let's say she doesn't have an attorney. Okay, so the monetary sanction ain't going to have. My only other recourse is to find you in contempt of court, and the law says I can sentence you to 25 days for each time I find you in contempt. But you know what? I'm going to cut you a break right now because there's 3 months you haven't paid. The only month I'm going to find you in contempt on is the first month. I'm going to sanction you to 25 days on the first month. But you know what? You owe a total of $750. You can purge that right now. This can all go away, but you have to follow my order and pay it.
But shouldn't you bring that over to the justice of the peace to do that?
No, the law doesn't require me to do that. The law does require me to conduct an evidentiary hearing. There's there's certain factors that I have to consider. Why wasn't it paid? Ability to pay, things along those lines. But you would be shocked how many cases we deal with where there's a clear ability to pay. They just disagree and they're not going to pay. Okay, and if we allow that to happen, we can't allow that to happen.
It's kind of one of those situations. Like, I understand where Steve's coming from because, and I agree with Steve on this one. Just for clarification purposes, if nothing else, like civil proceeding, should a civil judge be able to lock someone up? But at the same time,
contempt powers. Yeah. I mean, we don't do any sentencing. I mean, we don't have quasi. I mean, we have the juvenile court down there too. But I'm not talking about I'm not talking about juvie cases right now. But you got to, if you think of it from that perspective, you can't let people flaunt valid orders. If you do that, you're just setting up. So you have to have a system to hold people accountable. And right now, that's the system. Now, the one thing I can't do is in my opinion, on a civil contempt, I can't say you're going in jail for 25 days and you're going to spend every day of the 25 days, regardless of how bad you feel about not paying. We can't do that. We have to set up that purge capability, and it's got to be a reasonable.
I have to say this: you have gonads coming in here and talking to us. Yeah. You really do, and I have so much respect for you for doing that. Well, and you have answered the questions without any type of defensive mechanism. You have answered it, pure and precise and with energy and explain. And you weren't defensive.
Oh, no. I mean, Steve, you ought to come see me in court sometime.
And I appreciate
that. I felt strongly about this. One of my jobs as an attorney, I prided myself on ability. You haven't heard me use very much legalese whatsoever, okay? I prided myself on my ability to communicate with average, everyday people to try and get them to understand.
And that's vitally important in the family court.
I think if people understand. Look, did I win every family case I had? Anybody tells you that's lying. Did I have very many unhappy clients? Absolutely not, because I was honest and they knew what to expect. Now, carry that on to the judge, okay? Of course, my job is to determine facts and impose judgment upon people, but I also believe part of my job is to explain to people what is going on and why it's going on. Absolutely. And if you came sit in my court, you would see. Now, I don't take any, pardon my French, I don't take any bullshit, okay? This ain't yell at judge time. That's not that's not how this goes. But I pride even on the bench, even when I'm dealing with attorneys, I don't use a lot of legalese. I mean, sometimes I have to refer to statutes or rules of civil procedure, but I try because
they should know that.
Well, of course, but the reason why I do it is if they have a client on side of him or her, and the ruling goes adverse to the position that they're taking, I try to set up a situation where the client, unless they're just not listening, that happens sometimes too, but the client has a basic understanding of what's going on. I told somebody in court today, look, I understand people listen to their attorneys. They They hear, they don't necessarily listen. So I'll tell people in court, this isn't your attorney telling you this. This is coming from the mouth of the horse as to why this is happening. And I hope they place value in that. So yeah, I'm not look, man, if I were to sit here and tell you I'm right 100% of the time, I'd be lying to you.
You have a lot of civility. I got to say that.
I appreciate it.
And I thank you.
That's why I did good with juries.
And I thank you for that.
And
Jim?
so I just have one last question. And honestly, for once, this will be my one last question.
We've heard that before.
I know. Yeah, several times. Several times.
Judge, one more question.
Yeah, right. Yeah, several times. But no, seriously, family court is, we've been dealing with family court for years, and we've had family court judges come on, and we've had attorneys, and I've had attorneys say they will never step foot in a family court ever again. They won't practice family law because there's no rules to it. It's a free-for-all. None of the judges follow the Constitution. They don't know what the rules are, so they're not even going to try family court anymore. And then as a judge, these things are so emotional. You're dealing with all these crazy emotions, custody cases and things of that nature. So it just seems to me like it's got to be a very tough job, not just from a legal standpoint, but from an emotional standpoint. So what is it that makes you want to do this job? Because God bless you for being willing to do it, because we need family court judges.
I was blessed my entire career. I'm like a duck. Stress just full. And I was a trial attorney. Okay, I did over 100 jury trials. I probably tried, if I sat here and told you how many I know I tried 700. I mean, I tried a ton of cases. I never took things home with me. Now, when I'm in the office, I work like a SOB. Okay, nobody's going to outwork me. It just won't happen. But I just had this innate ability to be able to go home and leave things at the office. The same thing applies as a judge. I put my time in. If you work hard enough, now that termination case I was telling you about when I went home that night, that bothered. There's been 2 or 3 times where I take issues home, but I just don't do that. I don't know. I guess I'm blessed. I have an ability. Now you mentioned something else. No rule. Certain people are going to like the way I administer court. Certain people are not going to like the way. Steve doesn't remember this. Steve met me 10 years ago. He asked me a question. I told him, okay, my courtroom will not be a therapy session. That ain't what goes on in my court. I am not a therapist. I'm a damn judge. Okay. And my job as a judge is way, way different from the job as a therapist. You come before me. Listen to what I told you. You have the opportunity to settle this. That's why we send you to family mediation. You come before me without a settlement. This ain't a thing where I send you back out and set your return. I give you a trial date. Right. We're going to try your case. And I do it within a 6-month period of time too. Okay. Just so you know. Yeah. So, I mean, and maybe that has something to do with why I don't take these things home with me. I realize I am not a therapist. Okay.
You finish it.
I get it done. I get it done. So, do we deal with stressful situations? You better damn well. If you heard some of the, if you knew some, and it's not just as a judge in my 30 years of practice law. I mean, I tell you, man, I've seen some crazy stuff. It goes on and on. I spoke to a group I spoke to a group about domestic violence. I actually was involved in 2 cases where a spouse was murdered in relation to domestic. I mean, I've dealt with I've dealt with cases. I tried cases involving deaths of 9-month-old children. I had to put on a juvenile case one time involving the death of a child. There was a finding. We appealed, or a writ. It was a juvenile case, probably a writ. The Supreme Court sent it back down. I had to try it again, sent it back down again. The 3rd time, I couldn't even look at the autopsy pictures anymore. Because every time it was a different DA, and she shows me the autopsy picture, and the judge knew I literally threw them on the ground. We deal with some really, really crazy, stressful stuff. It's just the nature of the beast. But you have to, I don't know. I guess I can decompartmentalize. I don't know. I've never been the kind of person that takes things home with me. And knock on wood, it continues.
I appreciate you coming here and you could answer the tough questions, because there's a lot of people don't want to, don't know how to, or can't, or don't even have the wherewithal to answer tough questions.
Steve,
don't want to be challenged.
This is my life. This is my career. I enjoy discussing these things. I tell people in court all the time, it is okay. And this is something I think we've lost as a country. It is okay to disagree. Mm-hmm. We can have different opinions. The key to having a different opinion, this is what I do in my motion calendar, okay? I prepare everything before I come in. They always have competing opinions, otherwise they wouldn't be before me, okay? But I sit down and I listen, because who am I to say that you can't talk me into your position? I don't know if you're going to talk me into jury trials on domestic cases. We would have a backlog in court like you wouldn't imagine. From a practical perspective, I just don't know if that would work. I did hear about a state that give like 4-person juries on domestic cases. Is it Texas? I don't remember which state. But look, this is what I do for a living. This is my profession. I think I'm reasonably intelligent. I can state my position. I can listen to your position. You can tell me why you think I'm wrong. I can tell you why I think you're wrong, and we can shake hands at the end and say, okay, we can agree to disagree. That's okay. That's okay. I tell people that in court, we can agree to disagree. Unfortunately, I'm the judge.
Right. Yeah. True.
So ultimately in the courtroom, it's my final opinion that counts. But we can agree. I can listen. That's where good advocacy comes into play, and that's how I was trained. You take a position. Let me tell you something that's probably even harder than being a judge, and attorneys need to watch this. I lost a jury trial one time. 2 of the jury trials I lost had to do with people drinking in casinos. And I realized that jurors here in Las Vegas have very little empathy, for lack of a better word, for people who are consuming alcohol while they're and they get hurt. It was just something that, in one of the cases, it's tough. As an attorney, you got to watch taking a case. I guess what I'm saying is this: you got to really believe in the position that you're taking. Because your personality, you almost have to take on the person. That's why I love trying cases. You ever heard the old saying, all the world's a stage? As a trial attorney, you're a player. Okay, it's fun. You got to be passionate. You got to take on that client's position, and you got to assert that client's position. So I would tell attorneys, be careful taking on cases that you don't believe in strongly. You're much better off. Now, from a business perspective, it's always hard to send a potential revenue out the door. But you're better off if you don't feel strongly about the case. Send that case out the door and hope that the next one that comes in, you feel strongly.
Don't do it for a paycheck.
That's unfortunately,
especially when you're messing with people's lives.
Unfortunately, here in Clark County, we have a lot of attorneys now. We've heard, there are good things about California. There are bad things about California. You can just say
Marshall Willick. You don't know.
Marshall's a sharp guy. What I'm saying is this: California particularly California went through a stretch where they had a number of law schools and they produced a lot of attorneys. When you produce a lot of attorneys, you're going to have competition. When you have competition, when you have extensive competition. When you have extensive competition, you have people. I mean, the reality of the situation is you got to make a living. So sometimes people will take issues that they don't feel strongly in, and that results. We have the advent of the law. The law school's known as 20 years, if I'm not mistaken. And the only reason why I mention that is we're graduating. I don't know how many. Let's just use a round number: 100, 150 a year, and maybe more, maybe less. I don't know. But the only point I'm making is that with that advancement of the number of attorneys in the bar, the competition becomes much difficult, and I think much more difficult. And I think that's what we're starting. But it's been like that for years now. To be honest with you, you go back to the 90s, and you didn't see as much of that as you see now. But that's just a factor of growth in our community. That's all that is.
Well, Judge Gaudet, did you have anything that we haven't covered that you'd want to cover?
No. I leave that to your discretion. I'm here to answer questions.
Well, we really appreciate you coming on. Mark's going to zoom in on you. And then your final say, why people should go and retain you, your point of contact, website, email, stuff like that.
Once again, my name is Paul Gaudet. I'm a 32-year licensed attorney here in Clark County. I've been your family court judge in department and of the family court for a period of approximately 10 months now. I was appointed during 2023 by Governor Joe Lombardo. I like to think that based upon my experience, my efficiency, my tact, I'm well qualified to be a family court judge. I ask for people, I think something was said at the beginning of this, learn about your candidates for judge. It's a difficult thing to do, but if you learn about them, it'll give you more knowledge when you go into the voting box. I think that learning about judges and voting in accordance with what you learn is probably the best way to ensure that we in Clark County have the most competent bench that we can have. I thank you guys for the time. If anybody out there wants to go to my website, it's online now. It's GaudetForJudge.com. Gaudet, I'm probably going to be the only French name on the ballot, I would think. Remember, it rhymes with Monet, Gaudet. So in any event, I thank you guys for your time. I really do.
Thank you, Judge Gaudet.
Absolutely.
Thank you, Jim. Folks, that's Paul Gaudet, Clark County District Court Judge, Family Division, Department N. And not too many judges will come on this program, family court judges would come on this program and explain the family court bench to our audience. And I have a great deal of respect for this man for doing that. This is Steve Sampson, Jim Jonas for Veterans in Politics. Until next time.